Good morning, everyone, and welcome to day 3 of the Crammer. My name is Thando Manenza, and I want to thank you all for joining us today. Today, we'll be discussing the impact of the unusual circumstances of the year and how these circumstances have forced us to ask serious questions regarding the legal obligations that we may have taken for granted in the past. But before we get into our discussion, let's get a wrap-up of yesterday's highlights from Darren in his unusual workplace session. Darren, over to you.
Thanks very much, Thando. Yes, we had a great session yesterday. Thanks again to all of those who joined us. I hope you found it informative. Certainly the comments in the chat box were very encouraging indeed. Those who did perhaps missed it, there is the recording on the website. Please go to our microsite and you can download it there. And also the workplace survey, the results, the white paper was published for the first time yesterday. It is in itself a very interesting document. It's got some really interesting statistics. 88% of those interviewed would either work from home exclusively or as a hybrid model. This coinciding with Microsoft's decision on Friday last week to make work from home a permanent option means that really employees, employers all have to look at this in great detail, and I'm sure you'll find some informative insights and helpful advice in that survey. From the question side, are those who put questions in the chat box, and I'd encourage you to do it for today's session as well. We didn't get to all of them because it was all crammed into but we have gotten back to those people on email and had a side discussion on those particular questions. So if it's not answered online, I'd encourage you to put it in the chat box anyway, and we will get back to you afterwards. All that. And of course, our session ended up with some great unusual stories. Those unusual stories are published on our website and are very inspiring and a great end to the session. I wish you all a wonderful session, Thando, and audience, get involved. It'll be fantastic.
Thank you, Darren. Sounds like you had a lot of fun yesterday. The story I want to take from this year is the manner in which the world has reacted to the devastation of the pandemic. We saw this in how our government reacted swiftly with the introduction of the COVID-19 measures, and we saw it in how medical practitioners were selflessly on the front lines in fighting against this virus. You and I have also been part of this fight through our collective efforts in keeping our businesses and practices going in unbelievably trying circumstances. It is this ingenuity and innovation that we at Adams & Adams celebrate, and it shines through in the unusual client segment we have introduced to this year's Crammer. We've introduced this segment to shine a spotlight on some of the ways our clients have been innovating to keep their businesses alive. I've taken inspiration from these clients, and I think some of you will enjoy these stories, so please stay with me until the end. I'll go into greater detail regarding the segment. What we've also seen this year is the inadequacy of some of the legal obligations we negotiated in some of our contracts. The same contracts that took hours to negotiate have simply not provided us with the safeguards that we have required to deal with the effects of this pandemic. We've seen many examples of companies coming up with new and innovative ways to do business in the midst of a pandemic. However, simply put, one of the greatest risks to innovation is contractual provisions that do not properly safeguard people's interests. Today, our speakers will be discussing the challenges that have been experienced with construction contracts, with lease agreements, and in the processing of insurance claims. And our hope is that you'll gain some insight that might assist you with any challenges that you are dealing with in your own personal circumstances. What we are at the end of the day dealing with is a contract. Even though it relates to the construction industry or a lease agreement, at the end of the day, it's underpinned by a contract. So many of the issues discussed today can be extrapolated to those other contractual scenarios. Our speakers will have a Q&A session towards the end, where you can ask as many questions as you want. So let me introduce our first speaker. Please welcome Vian Menkes, who will be discussing some of the challenges in the construction industry.
What an incredible year 2020 has turned out to be. What an unusual year 2020 has turned out to be. It's been a year filled with unusual events and unusual circumstances. Economies have been brought to their knees. Various sectors and industries have been impacted. And me presenting my Crammer 2020 talk from an abandoned construction site, it's clear to say that the construction industry has not been spared. Global supply chains have been impacted severely. Health and safety protocols on site, compulsory social distancing protocols, those have all impacted productivity, and it's increased costs and led to various delays. Various other curfews and restrictive measures have also halted contractors in implementing and planning acceleration programs. All of these effects of COVID-19 and lockdowns around the world could not have been prevented, could not have been foreseen, could not reasonably have been foreseen or planned for. And you'll be forgiven if you didn't plan for this in your contract. Here's a thought. Is that not why we conclude contracts with so many provisions that usually don't even get referred to during the currency of the project? Is that not why we conclude long-winded and complex contracts? To provide for unusual circumstances and to prevent them, or to at least protect parties when they take place. And is that not even more so when you look at construction contracts? NEC, JCT, JBCC, FIDIC, GCC. These are contracts drafted, reformulated, debated, changed year on year by massive committees and some of the smartest and brightest legal minds around the world. Surely these contracts must protect us in circumstances such as these, protect the parties to contracts, protect the parties to construction projects in unusual circumstances and unusual events. Unfortunately, that's not entirely true. And although, to a certain extent, these contracts provide recourse and provide protection to parties to a construction contract in these circumstances, it doesn't entirely do so. Let's start with force majeure. I'm sure all of you have heard of that phrase, and all of you have heard of force majeure during these times. Force majeure is not a codified principle. That means that you won't find it in an act, you won't find it in a regulation, you won't find it in any national or provincial act or legislation, and you can't go to an act and say this is the meaning of force majeure and everyone knows that that's the meaning. In other civil law countries, South Africa is a common law country. In many civil law countries, UAE, France, China, Argentina, those countries have force majeure as a codified principle. There you can go to an act and see the definition and see the effect and the event that under which it will find application. In South Africa, that's not the case. Force majeure is a contractual provision. If it's not in your contract, it's not applicable. If it's not in your contract, then you need to fall back on common law provisions, such as vis major, causus fortuitus, so-called supervening impossibility. But I'm not going to go to the common law provisions for now. I'm going to have a look at force majeure because it is dealt with in these contracts. It is there. But what's the effect and what are we trying to answer here? Well, let's look at two scenarios. The one from a contractor's perspective. What if he's had a supplier in China that supplied steel to him over many years at a certain price and at a certain leading time? He has become used to this price and become used to the time that it takes to procure that steel. He priced for it in his BOQ and he planned for it in his program. Now with international travel restrictions and lockdowns, he may not be able to procure the steel from that specific supplier. What now? Well, he needs to find an alternative supplier. Let's say that's another foreign supplier or even a local supplier, which provides the steel at a much higher rate and with a much longer lead-in time. What then? Can he claim an extension of time? Can he claim additional costs? It's a very important question. What about an employer? If an employer's business has been so severely impacted that he doesn't have the cash flow, he doesn't have the money because his business was closed for a month or 2 months or 3 months or even till today. He doesn't have the money, he cannot pay his contractors. Can he say, well, force majeure, guys, I cannot pay. Please help me, let's look at the contract. Those are two valuable questions and important questions to look at. Let's look at force majeure. Does it protect the parties? Let's have a look at it in FIDIC and JBCC.
In terms of the 1999 FIDIC Red Book, force majeure is dealt with extensively under Clause 19. In terms of Clause 19.1, force majeure is defined to mean an exceptional event or circumstance, A, which is beyond a party's control, B, which such party could not reasonably have provided against before entering into the contract, C, which, having arisen, such party could not reasonably have avoided or overcome, and lastly, which is not substantially attributable to the other party. The clause then goes on to list certain specific force majeure events under subparagraphs 1 to 5. and you'll see in a moment why this is important. As for the consequences of force majeure, clause 19.4 states that if the contractor is prevented from performing any of his obligations in terms of the contract by force majeure, then the contractor shall be entitled to an extension of time and, under limited circumstances, to additional costs. Two things are important to note in this regard. The first is that there's no obvious recourse available to the employer if force majeure events take place. The second important thing to note is that the contractor will only be entitled to claim additional costs if circumstances under subparagraphs 2 to 4 of clause 19.1 take place. These events and circumstances include events such as rebellion, terrorism, commotion, riots, radiation, or radioactivity. And none of these events can easily be couched as COVID-19 or lockdown events. As for the JBCC suite of agreements, the first time that force majeure was brought in was in edition 6.1. It wasn't dealt with in earlier editions such as 4, 5, 5.1, etc. The definition of force majeure is similar to that as in FIDIC. And in clause 1.1, force majeure is defined as an exceptional event or circumstance that A, could not reasonably have been foreseen, B, is beyond the control of the parties, C, could not reasonably have been avoided or overcome. Similar to FIDIC, clause 1.1 goes on to list certain specific circumstances that may qualify as force majeure events. As for the consequences of force majeure, these are also similar as those in FIDIC. In terms of clause 23, the contractor is entitled to a revision of the date for practical completion by the principal agent without an adjustment of the contract value or a delay to practical completion caused by force majeure. This is similar to that in FIDIC, and the contractor will, although he will easily be entitled to an extension of time, not be entitled to an adjustment of the contract value, i.e. additional costs, if force majeure events take place.
That brings me to the second provision that I want to talk about, and that's change in law provisions. I don't know if you've heard of it, but it's actually a critical provision for contractors, in these times at least. These provisions state that to the extent that a contractor incurs more cost, spends more money because of a change in law, because the change in law led to those costs, then he will be able to claim the costs. But there needs to be a specific link between the incurrence of costs and the change in law or new regulation. A regulation stating that no construction sites may be open for 2 months. That's a legitimate cause of action here. Then the contractor can go and say, well, I can get my 2 months extension of time, either because of force majeure or other provisions, but I can also get prolongation costs, additional P's and G's, etc., because of those 2 month additional time that I now need to cater for.
So let's have a quick look at the change in law provisions in some of the standard form contracts. In terms of the 1999 FIDIC Red Book, change in law is dealt with in clause 13.7. That clause states that the contract price shall be adjusted to account for any increase or decrease in cost resulting from a change in the laws of the country which affect the contractor in the performance of his obligations under the contract. Interestingly, the definition of laws in the 2017 suite of FIDIC contracts is much wider and now also includes decrees, rules, ordinances, treaties, and/or international laws. The provisions in GCC is similar. In terms of clause 6.8.4, if any act of parliament, ordinance, regulation, or bylaw of any local or other statutory authority is amended and this results in additional or reduced cost to the contractor, such cost shall be added or deducted from the contract price. Similarly, in NEC 3, in optional clause X 2.1, a change in law of the country in which the site is located is a compensation event. The project manager may then notify the contractor of such compensation event for a change in the law and instruct the contractor to submit quotations. This will also lead to an adjustment of the contract price.
So that takes care of a contractor scenario, but it begs the question, what if the law hasn't changed? What if other restrictive measures or other scenarios have led to additional costs? What if other scenarios have led to delays? You can't really fit it into force majeure and you can't fit it into change in law. What then for the contractor? And the question remains, what about the employer? What about the employer's business that's been so severely impacted because of COVID-19 and lockdowns? What can the employer do? Well, creative solutions need to be found here. We need to go back to the drawing board. We need to consider these contracts carefully. We need to consider each and every contract and look at the provisions and see where we can find recourse. We also need to look at these contracts more critically when we enter into them in the future. We need to, in hindsight, look at what we've learned, look at the damage that has been caused, look at construction sites such as these that have been standing still where employers and contractors are nowhere to be found. Financial ruins have taken place. We need to learn from this and conclude contracts more shrewdly, more creatively, and more proactively. We need to look at all of these things, and it's exciting times for us because we can learn from this, we can improve on it in the future. I hope that you've enjoyed this discussion, and I invite you to ask me a few questions after this, and hope we'll be in touch soon.
Thank you, Vian. Unfortunately, I understand that I've had some technical difficulties, and I really wish to apologize for all of that. As is happening with 2020, you have to keep on improvising, so I have moved on to my iPad screen. So I hope everything is a bit better, the sound is a bit better, and the picture is a bit better. Vian, thank you for that. Firstly, where were you? I think I missed that part in the video. Where's this construction site?
No, actually, I didn't say where I was because the parties to that site actually asked me not to disclose it. They've had various difficulties actually there. So it's in Pretoria. Let's keep it at that.
Okay. All right. Great. I think the first thing that you mentioned was that you discussed insofar as the responsibilities, people's responsibilities during this lockdown. So which party would generally have responsibility to maintain the site during the lockdown periods?
Yes, Taro, I think it's a fair question, and I think that question mainly comes from the uncertainty that lockdowns brought. And parties for some reason, and perhaps understandably so, forgot about their contracts once lockdown was announced. But it's important to go back to the contract and look at the contract, because the provisions in all of these construction contracts are actually quite clear on who's responsible for the site, who's responsible for safety on site, maintenance of the site. If you have a look at FIDIC, clause 4.22, JBCC clause 8, all of those clauses say that the contractor, until practical completion has been reached or until site handover has taken place, the contractor will be responsible for site safety and for site maintenance. So, even if lockdowns ensue, and no matter what the lockdown level is or what the effects in the background is, the contractor remains responsible. But it's also important just to have a look at your specific contract, because some of the contracts may be amended to say that the employer carries, additional risk during those times, or need to assist the contractor in safety and maintenance of the site. But generally, it's the contractor, and lockdowns won't necessarily have changed that responsibility.
I understand. The nature of the construction industry also is that you've got these agreements, these JBCC agreements that have various editions and various versions. And there's a question I want to ask after this about that. But for present purposes, if you have a version of an agreement that doesn't necessarily have the force majeure provision, so I understand versions such as edition 4 and 5 don't have these force majeure provisions. Is it a simple case of just copying and pasting from the versions that do have force majeure contracts? How would you advise our clients go about that?
Yeah, so I touched on it briefly in my discussion, Thando, and it's version 6.1 was actually the first version of the JBCC suite that dealt with force majeure, that had a force majeure clause in. And versions 4 and 5, which are still the versions mainly being used these days, don't have force majeure in, and those are leading to various disputes and uncertainties. For new contracts going forward, should you include a force majeure clause? I'd say most definitely so, for the simple reason that it creates more certainty. It gives you a fallback. And as I said, force majeure on its own doesn't mean anything. If you have 100 phrases of force majeure in your contract, it doesn't mean anything. It's all about the substance of your force majeure clause. And if you have a look at these contracts and you have a look at the various definitions of force majeure across these contracts, it's different in each and every contract. So to copy and paste from one of the versions or from one of the suite of agreements that you particularly like is also not advisable. You need to really tailor your force majeure clause and really expand your force majeure clause as much as possible. Because I mean, we've seen, and we've seen strange force majeure clauses, in bespoke construction contracts where parties copy and paste certain provisions that they've liked from previous agreements, and that's really not the way to go. You need to make sure first your force majeure clause, dovetails with the rest of your agreement, but also that it caters for your specific requirements. And I mean, if we have a look at 2020 and what this year has brought for us, we'll be able to draft force majeure clauses in a much more, open-minded manner, because your force majeure clause is always probably your boilerplate provision that you just pop in at the end after you've prepared all your important clauses and everything that everyone thinks are important, and not a lot of time is spent on that. But I think after 2020, people will spend much more time, and rightly so, on force majeure clauses. And we need to look at this year, what this year has brought, look at all the different contracts where we have good force majeure clauses, where we don't, and really tailor them for specific projects and for specific circumstances to really be, in line with what we need.
Sure. No, thanks, Vian. I think, look, I have one more question to ask, and maybe if we can try answer it in as quickly as possible, so we can give other carry on with the program. But in the beginning, you mentioned the fact that your JBCC agreements are not common law agreements at the end of the day, and the benefit of a common law agreement is that you have judges or people that pronounce on it, and the nature of it would change to deal with new issues that might arise in the future, which is obviously the benefit as compared to a codified piece of legislation. Are you finding that people are learning from the mistakes that they're making in this industry, and that they are updating and upgrading their future agreements to deal with things that they've dealt with in the past?
Absolutely, Tando. If you have a look at JBCC, only on that suite of agreements over the years, it's improved, but it's also become more complex. As you can see in the last version, we've got force majeure in. I'm sure in the next version we'll have even more, more broad and more comprehensive force majeure clauses. And I think definitely people are learning. These committees preparing these agreements and drafting the agreements are really industry experts, and they come from various fields, lawyers, engineers, etc. So I'm sure they'll learn from this, and they'll really tailor the future agreements to at least provide a little bit more recourse and a little bit more certainty if similar events such as in 2020 take place.
Yeah, thanks, Vian. And of course, if our clients have an issue, they can always come to you for advice. But thank you very much, Vian. That was a great video. Hopefully things work out for the client in Pretoria.
Let's hope so.
All right. Now we're moving on to our second discussion. It's going to be Gabriella who will be discussing, some of the difficulties that lease agreements have experienced as a result of the COVID-19 pandemic.
The COVID-19 pandemic has impacted a lot of businesses in South Africa due to the lockdown implemented by the South African government. During level 4 and 5 of the lockdown, most businesses were requested and obliged to close, except for businesses that are involved in the supply of essential goods and services. Currently, we're in level 1 of the lockdown, and a lot of businesses are still experiencing and struggling financially. At the moment, landlords and tenants are going through a lot of pressure to meet their lease agreement obligations. So much so that currently tenants are struggling to fulfill their obligations by paying rent, either because of the lack of foot traffic or due to the long period of time in which businesses were closed. This is why I'm going to be discussing the options a tenant would have for early termination of a lease agreement, as well as what to consider when entering into
the sound has disappeared on our side.
Future. So while discussing lease agreements, I'm going to be focusing on commercial lease agreements specifically, as opposed to residential lease agreements, and doing so from the tenant's perspective. So where you have a tenant that is going through financial stress, it's important to consider the lease agreement itself, to have a view of what it says exactly. So the clauses included in the lease agreement. As most lease agreements include a clause that would allow a lease agreement, a tenant to, for a moment, halt their lease agreement obligations for a period of time. This clause would be called a force majeure clause, which would mean that due to a specific event, the tenant would be able to cease their obligations for a period of time. So it would be important to review that clause, as depending on what the clause states would determine whether a tenant would be able to rely on that clause. To the extent that a tenant does not have that clause in their lease agreement, a tenant would be able to rely on commercial common law. And the common law would allow the tenant, where in the instance where they are unable to have the use and enjoyment of their business premises due to an unforeseen event. This is called vis majeure. So this is another way of simply suspending their lease obligations. And to the extent that a tenant would currently, during level 1, want to rely on vis majeure or force majeure, a tenant would have to first off review, as I said, the lease agreement. And unfortunately, it would be very unlikely that a tenant would be able to rely on force majeure and vis majeure currently during level 1, as most businesses are currently open and operating. And vis majeure relies on a tenant being unable to use the premises. With force majeure, one would have to review the clauses in the lease agreement, but because currently most restrictions have been lifted, it's unlikely a tenant would be able to rely on those clauses. Now, this means that during level 1, a lot of tenants are currently experiencing hardship, economic hardship, and even though they would not be able to rely on force majeure or vis majeure to suspend their obligations or to terminate their lease agreement. So it begs the question, what do you do next? If suspending your obligations in terms of a lease agreement would not be sufficient to solve the problems of your business or your financial crisis, what next? The tenant would have to then consider the options in terms of early termination of their commercial lease agreement. In terms of early termination of their lease agreement, a tenant would have to think carefully as to whether this is the route they wish to follow, as termination as a drastic measure and should be taken only as last resort, as early termination usually results in significant penalties for doing so, depending on the lease agreement itself. So it would be prudent for a tenant to consider the following options, being, first one, business rescue. Business rescue is a very good option where the business is still viable but unable to pay its debts, as a business rescue practitioner would take over their business obligations during that period, and it would result in a moratorium. A moratorium is a period of time where there would be a cease in enforcement action. This period may actually allow businesses to get back on their feet and to have a look at their finances and to see if they can't get back into the business sector. Now, it would be important to weigh up your options with business rescue, considering it and the costs involved, as going into business rescue and pursuing that application may be actually more costly than simply settling with the landlord, which leads me to the next option, which is merely settling, negotiating, and entering into a settlement agreement with the landlord. One would go about this by merely giving notice to your landlord in accordance with your lease agreement, entering into negotiations with your landlord, and coming to some sort of settlement. At the moment, unfortunately, there isn't really an incentive for the landlord to actually consider the tenant, as it's currently difficult to replace tenants during this climate. However, one must still bear in mind that a landlord has an obligation to mitigate their damages as a result of the early termination. This can be done in many ways, such as advertising and doing their part in trying to replace the tenant by putting out advertisements and going about replacing the tenant. And so having said that leads me to the next option, which is the replacement of a tenant. The tenant themselves can go about finding a replacement tenant where that tenant would take over the obligations of the lease agreement and replace them as a tenant. But as I said before, this is difficult because at the moment, most businesses are looking to downsize and to reduce office space rather than take on new office space. Another option when considering early termination is to consider whether a tenant would be able to rely on the Consumer Protection Act, which allows for certain relief in the sense that it allows the tenant to terminate early, with the landlord only being able to claim reasonable penalties, which is substantially better than could be just negotiating one-on-one with the landlord. So bearing in mind all these options when considering early termination is extremely important, as there are many options available to the tenant when deciding on terminating your commercial lease agreement early. This leads me to the next point, which is considering what should be included in the commercial lease agreements going forward to avoid finding yourself in the position where you have to terminate your lease agreement early. A tenant would need to consider the length of the lease agreement, as a lease agreement that's too lengthy may not be to the advantage of the tenant, as well as making sure that there are clauses in the lease agreement that deal with hardship, such as a hardship clause, where it would provide clarity regarding the obligations of the tenant and the landlord in a circumstance where there is a situation where the tenant finds themselves in financial difficulty, and whether the obligations can be suspended for a period of time or stopped for a lengthy period of time until that hardship period is over. This is all negotiated between the tenant and the landlord, but it's an important clause to include, as well as a pandemic clause, which would be extremely preferable and useful in a situation like this, and a similar situation, as we don't know when we would find ourselves in this situation again, where it would indicate what the obligations would be during a pandemic of the landlord and the tenant. So these are the important clauses to consider going forward when concluding a new lease agreement. Now, having considered the position of the tenant, it's important to have in mind what would work for you as a tenant and your business, because merely suspending your obligations in terms of the lease may not be for you, and you have to review whether this is something that would benefit your business, or whether early termination is the only option, and bearing in mind all the options made available to you during this time. And going forward, it's important to make sure that you review your lease and negotiate to include all the relevant clauses that would benefit you in future during COVID-19 or like pandemic situations.
Thank you, Gabby. I think this is probably one area that globally there's been a lot of hardship with this pandemic and the measures that the government has put in place to try to curb the effects of the pandemic. People are not being able to pay their rental. So it's a very difficult thing that everybody's been going through regarding this industry. I think the first thing that I'd like to discuss, one of the first questions that have been put through by our clients, what happens if a tenant simply does not pay rent during the level 1 lockdown due to financial difficulties?
That's a very relevant question at the moment. Failure to pay or continuous late payment or withholding payment at the moment is a violation of the lease agreement itself, and such action would cause a breach of the lease agreement and would allow for the landlord to claim damages and a penalty depending on what the lease agreement itself says. But it opens the door for breach. And that's never a good thing on the part of the tenant. So a tenant should be very careful in terms of just withholding payment of rental during difficult financial times. As I said in my discussion, it's always important to negotiate with your landlord, or even better, have included a clause that would be able to assist you in such difficult times.
I understand. And I mean, just out of interest, is there, would the position be any different if it's level 3? Or do you think it's just the level 1 lockdowns has made it easier for people to start earning an income and then start meeting their rental obligations? So the vis majeures and the force majeures might not be of assistance to them in level 1.
That's exactly true. During level 1, force majeure and vis majeure, it's very unlikely to rely on those provisions that would have been of help during levels 3 and 4. So currently, as I said, the companies and businesses are experiencing financial difficulties that stem from level 4 and 5, but yet are unable to rely on a vis majeure and force majeure, which would have suspended their obligations and possibly assisted them in reestablishing themselves and to get them back on their feet.
I see. Yeah. We have a lot of unscrupulous landlords that, especially in the commercial space, who might take advantage of these particular situations and the bad situation that we're in right now. Can a landlord unilaterally increase the tenant's rental this year, bearing in mind the lockdown? I'm assuming over and above the normal escalation that would be in the contract. Can the landlord merely increase the rental in that way?
No, a landlord, there is no position to increase the rental unilaterally. There needs to be a provision in the lease agreement to enable the landlord to increase the lease. Alternatively, the lease may be increased to a reasonable amount. So a reasonable amount can be added to the rental, but unilaterally, where there is an agreement present, the agreement would of course stand. So where there is an agreement for increase, and the increase that is taken by the landlord is unilateral and different from what has been agreed to, that would not be acceptable and would be grounds for discussion and possible litigation. I
see. Just one final question. This might be a bit of a tricky one to unpack here, but I'd be interested in hearing your thoughts. What is the position of a surety in the lease agreement, where can that surety rely on the inability of the tenant to pay due to force majeure?
That is a very interesting question. The surety may still be able to rely on force majeure if it was level 4 or 5, but currently during level 1, the status quo remains. And having said that, surety would then have to stand as surety and pay in place of the principal debtor, which would have been the tenant. So they would not be able to hide behind force majeure or vis majeure currently during lockdown level 1. They would be forced to pay or to deal with the claims as they come, as force majeure would not be able to be relied on in this time.
Great, thanks, Gabby. I mean, a surety can rely on the defenses of the primary debtor to the extent those are valid. So, but yeah, it's an interesting question. Thank you, Gabby. That was very insightful. Thank you very much for taking us through that.
It's a pleasure. Should you have any further questions, you're welcome to contact me.
Great. Thanks, Gabby. All right. So moving along to the next topic, which has also been quite a topical matter in our country right now. CB is going to take us through some of the challenges experienced with insurance claims during this pandemic.
Sibu, thank you once again for joining us as we'll be discussing the impact that COVID-19 has had on insurance claims. To start off, this venue is very stunning. Can you just tell us where we are and what we're doing here today?
So we are at a restaurant called The Rock, based in Fourways, one of my favorite restaurants. Places like our location have had their doors closed to customers following the imposition of the lockdown regulations that were imposed by government in an effort to slow down the spread of the virus that causes the disease COVID-19.
Recent media reports have spoken about an insured party that has penned an open letter to one of South Africa's biggest insurers regarding their refusal to pay their business interruption cover claim. Can you just tell us what business interruption cover is?
So business interruption cover, or BI cover, is a cover that replaces business income that is lost as a result of a specific event. So the purpose of a BI cover is to assist a business to survive an interruption when they're not generating income, but they may remain liable to pay rent and salaries.
So you say business cover or BI cover kicks in when there's been a loss of income as a result of specific events. Can you give us some of the specific events that you're talking about?
So there are two types of covers. You get a standard business interruption cover, which covers the loss for physical damage to the insured premises. And then you get an extension, which covers contagious diseases.
It sounds like your typical insured party insurer relationship. And if that is the case, why are the parties then taking each other to court?
So the main reasons we're seeing parties go to court is because they are seeking clarity on whether or not it was the disease COVID-19 that caused the loss suffered by insured parties in the hospitality industry, or rather is it the lockdown regulations that causes the loss suffered by insured parties.
And what are some of the arguments that have been advanced in favor or on behalf of insurers in cases such as these?
So the two main arguments that we're seeing being advanced in favor of the insured party, or the insurer rather, is that firstly, BI cover wasn't intended to cover pandemics. And secondly, that it's not the disease COVID-19 that has caused the loss suffered by insured parties, but instead it is the lockdown regulation that has caused the loss suffered.
Can you just expand a little bit more on this argument of COVID-19 on the one hand and the lockdown regulations on the other being the cause of the loss of income?
So the argument is that COVID-19 and the lockdown regulations are two separate events, and the lockdown regulation breaks the chain between COVID-19 and the loss suffered in the hospitality industry. So the argument is that the peril that is covered in a BI cover is the disease and not the lockdown regulation.
Have South African courts rather had an opportunity to engage with such issues, and what are some of the findings that they've had in cases such as these?
So in South Africa, the Western Cape High Court had to deal with the BI cover in the Cafe Chameleon case, where the restaurant closed its doors on the 27th of March and they were generating income. So they brought their claim to the insurer. And so the court had to determine whether COVID-19 caused or materially contributed to the lockdown regulations, which then gave rise to the restaurant's claim. So put differently, but for COVID-19, would the restaurant have suffered a loss? And if so, is there a link between the disease and the loss suffered by the restaurant?
And in this case that you're speaking of, what did the insurer argue?
So the insurer admitted that COVID-19 is a contagious notifiable disease under the relevant BI cover. However, the insurer argued that the loss suffered is not caused by a peril covered under the BI cover.
And then in response to that argument, what did the court say?
So the court, in a nutshell, found that there was a link between the disease and the lockdown regulations, which then gave rise to the restaurant's claim. In other words, the court found that the insurer was liable to pay out the restaurant's claim under the BI cover.
So ultimately, are you saying that judgment was handed down in favor of the insured party?
So the Western Cape High Court did find in favor of the insured party and found the insurer liable to pay out. However, there's an appeal pending in the Supreme Court of Appeal. So we will await to see what the Supreme Court of Appeal has to say on the 16th of November.
And if that has been the direction that South African courts have been going in, what have other courts in other jurisdictions, given that COVID-19 has been a global pandemic, what have the courts in other jurisdictions heard or decided in cases such as these?
Yeah, so the interpretation of BI cover we're seeing is being debated in other jurisdictions as well. Earlier this year in May, a court in France found their largest insurer liable to pay out a restaurant for revenue lost during 2 months of their lockdown period. And fairly recently, we saw in the UK where the court said that lockdown regulations cannot be disassociated from the disease COVID-19. In other words, the courts are saying that COVID-19, the disease, is a proximate cause to the loss that we're seeing in the hospitality industry.
Now, going back to this Cafe Chameleon case, you said there's a pending appeal. And if in such instances, then where does that leave the insured party with their claim?
Yeah, so fortunately, we have seen that insurers are paying interim settlements to restaurants that have, or the hospitality industry that has made claims, pending the clarity that they're seeking from the courts.
And now, if insurers keep on appealing cases like these, will we ever see the finalization then between this disputes between insured parties and the insurers?
Eventually, we will. Of course, because it's being appealed, it may end up in the Constitutional Court, but eventually we'll get a final decision and interpretation of what is covered under these BI covers. But it could take some time as well. Alternatively, parties can decide to settle outside of court, outside of the Supreme Court, and so we'll see from there.
According to now your knowledge and the reading on the subject, what would you say that the future of insurance, specifically against global pandemics, looks like?
So this is a good time for insurers to reevaluate their role in a world that is increasingly connected. We've seen how quickly this virus has spread, how it has affected every single industry. So our insurers definitely have a task on them to figure out a policy that they can package for the market where the premiums remain affordable, but they still remain covered for such a high risk. So they have to sit down, put their heads together, perhaps even with governments, and see whether government can provide the primary cover in such a situation, and then the specialty insurers covers an excess. In both cases, whether it's the government getting involved or if it's just on insurers, we're going to see exclusions. So insured parties have to be very mindful of their clauses in the future where we'll see express exclusions in BI covers.
Now, lastly, Sibu, what are some of the takeaways that you would want whoever's been watching or listening to this discussion to remember, specifically regarding insurance and global pandemics?
Yeah. Firstly, thank you for listening to me. But the 3 things that I want you to remember post this Q&A is wording matters. You have to be mindful of the contractual terms that you are entering into as an insured party. Be mindful of the exclusions under your BI cover. Secondly, if you're an insured party, you bear the onus to prove that your claim is valid. When you have to prove your claim, there are time bars. Not a lot of insurers can extend those time bars because of their own reinsurance cover. Thirdly, and most importantly, supporting local matters now more than ever. Take that short left, visit your favorite restaurant like The Rock in Fourways, and take that short left to somewhere in South Africa.
Once again, Sibu, thank you so much for your time. This has been a very insightful discussion, and it's going to be interesting to see what the outcomes of all these court cases is.
10 seconds.
Thank you, Sibu. That was a great video. One of my favorite restaurants also. So I think it looked like you enjoyed yourself that day. The first question that I wanted to ask you, there's a concept of fair treatment to customers. Can you please perhaps just explain to our clients and to the public what exactly fair treatment to customer means, and does it apply to the insurance industry?
Certainly, fair treatment to customers does apply in the insurance or the hospitality industry. The court in the Western Cape did also mention that in the Cafe Chameleon matter, where the court said when you're interpreting insurance contracts, it has to be fair and sensible. One of the functions of the Financial Sector Conduct Authority is to encourage financial institutions to treat customers fairly. And what that looks like is providing customers with clear information, amongst other things.
Great. Yeah, so look, I mean, this is, it's a strange argument I think the insurers are trying to advance here in these cases. I understand in the UK they weren't successful, so I think they might have difficulties here. But one of the things that you've discussed is in relation to business interruption and the claims relating to the physical integrity of a building. Obviously, we've got a silent airborne killer here, which is not necessarily going to, break down physical integrity or physical structures of buildings. What is the position with business interruption and the physical integrity of buildings?
Yeah. So if we had to look at the joint communication that was published by the Financial Sector Conduct in conjunction with the Prudent Authority, they said that physical damage means physical damage. And so you have to look at the English dictionary to understand what does physical mean, what does damage mean. And you'd come to the reasonable conclusion that they're saying there that there has to be tangible injury to the insured premises. And they said that COVID-19 is not covered under a business cover. And that was quite a bold statement to make, because our courts haven't as yet had to deal with the question of whether the physical presence of the virus constitutes physical damage. So somebody could argue, depending on the terms of their standard BI cover, that they have had a loss of use of their insured premises. So the short answer is look at your contract.
Yeah. So look, I think that the insurers, knowing how they operate in their businesses, are going to be very well prepared to deal with these issues in their future policies. They're not going to get caught out if they, to the extent that they did, they're not going to get caught out in the future like they did now. But I'm just interested to hear your opinion on what an individual like you and I, who is not an insurer, who is insured, especially in the hospitality industry, what advice do you have for that person to make sure that their insurance policy is, covers all issues, and, to the extent possible, that you don't have insurers relying on such technicalities to avoid liability?
Yeah, that's a good question, because we see some of these insured contracts are very long, and the normal person doesn't have time to read a contract that's over 130 pages. So you definitely need an attorney to assist you, to have a look at the fine print, to have a look at what is excluded in your business interruption cover, because that's where they seem to be catching out the insured parties, is that, yes, you're covered, but look at this exclusion. Now look at that exclusion. And then also you have to be very mindful of going about proving your claim, right? So once you realize that you have a claim, you have to act quickly. Again, there's time limitations. You have to be able to prove. So you really do need the assistance of professionals, one, in understanding the terms of your contract, and then also you need assistance in quickly proving the validity of your claim.
Okay, great. Thank you very much, Sibu. That was very enjoyable, very insightful. Thank you for that.
It's my pleasure.
Great. So we're now moving on to the last section of today. I think it might not have been quite clear in the beginning, given the technical issues that we've had, but it's the unusual client segment, where we've given our clients a bit of a spotlight to try showcase their, their businesses, and to showcase how they have survived and thrived in most instances during this pandemic. The videos, and including these videos that you're going to see now, are going to be on our microsite, and you'll see on the chat section that there will be that the link will be up for you to have a look at a later stage. So the first video is from Mr. Shadrack Mtetwa, who is the CEO of Isibonelo Property Development.
Action. Hi there. My name is Shadrach Mteto. I'm the Chief Executive Officer of Isibonelo Property Services. We are based in Pretoria, in Gauteng. We are specialists in rural precinct development and as well as transport nodes. We have been in existence for a period of 20 years, during which we've managed to develop over 170,000 square meters of space, which houses the formal retailing and informal trading, as well as taxis. By nature of our business, we've encountered a number of challenges. There are only two challenges that actually shaped our business. One is a social issue, and the second one is human rights issue. However, we've managed to maneuver and resolve and get a better way of handling such issues by adapting to the needs of the community and at the same time to acquire intimate knowledge of the society where we're doing this development, which leaves us with the knowledge of saying, we develop and plan with our community, and we develop for the needs of our community and our stakeholders. This is our winning formula. I hope you get a better understanding of how our organization is as a specialist in a unique environment, which is informal trading and as well as the tax industry and rural development. I thank you.
Well, that was Mr. Shadrach Mteto discussing Isibonelo. Isibonelo is a client that I have worked with quite extensively in the past, and I can definitely attest to the fact that they are a resilient bunch. We have dealt with a number of issues, not including this COVID pandemic. So the next video is from Mr. Terry Turon from TNT.
Hi everyone, my name is Terry Turon and I'm the owner at TNT Digital Marketing and Communications. TNT is a holistic digital marketing and communications company that offers our clients a variety of services, tools, technologies, and solutions that improve the efficacy of all communication materials, both internally and externally. 2020 has been a challenging year, to say the least. It forced us to think in different and creative ways and re-look at our business focus by expanding and adapting our service offerings to best assist companies during lockdown. We started by offering online solutions for education and training facilities. This ranged from e-learning for schools, as well as staff training platforms for various companies. As staff are not in the office every day, we saw the opportunity to add business intelligence services to our portfolio in the form of online surveys, live audio and video streaming, a measurable communications platform, and data presentations and visualizations, providing actionable information which helps business owners and executives make informed business decisions. This time has allowed us to think out of the box to help companies and businesses work more efficiently in the new normal. To view a full range of our digital marketing and business intelligence services, please visit our website at tntdigicoms.com.
Great, thank you. That was quite inspiring. Like I said in the beginning, all these videos, the videos of today will also be on our micro site. The link to our micro site should be on the chat section of the video. So please log on, please take a look at the videos, share them, distribute them. We're really proud of what our clients are doing in the space. We'll also be sending a mailer to all our clients and to all the people that have signed up to watch today. That will also include a brief survey. It's the kind of things that we'd want to hear from you guys. It's a new format. Unfortunately, we saw some of the hiccups of that new format in the beginning of the video, but we're really proud of the Crammer and what we're doing this year and bringing it to you all in a new and exciting format. So tomorrow is a further day. Mr. Peter Fasaki will be the facilitator for our unusual opportunities discussion. So please join us again for that discussion. Any questions that may not have been dealt with today, our speakers will be available to deal with them and to respond to them. So all your questions will be responded to. So please feel free to keep sending in those questions. We're here to assist you. And I'd like to thank you all for joining us again. And on behalf of all the speakers, I say thank you and goodbye.